know people are trickling in, but we've got a lot to talk about tonight. So first of all, I just want to thank you all for being here tonight and joining us for this event. As some of you may or may not know, our present multiple court system really creates confusion among people the courts are supposed to serve, and essentially generates a system that's difficult, if not impossible, to understand. And this is an issue that the League of Women Voters has been working on since, I believe, the 1950s. So tonight we're really thrilled to have with us three of our presenters who truly have done a wonderful job advancing this issue, and especially one that's really important this legislative season. So first, I'd like to introduce Dennis Hawkins. Dennis is the Executive Director for the Fund for Modern Courts. He's traveled internationally to explain how Modern Courts works to achieve and support judicial independence in the United States. Previously, he was the Regional Anti-Corruption Advisor in Eurasia for the American Bar Association. And prior to that, he served as the Deputy District Attorney in Kings County. Thank you so much for being here. And with that, I'll hand it over to you, Dennis.
Thank you, Erica. I just want to tell you how delighted I am to be here tonight and to meet with all of you. I first learned seriously about the League of Women Voters when I spoke to Libby Hubbard, who actually was an executive director years before I took the position. And she told me about the power, the influence, the engagement of the League. And I have always appreciated the work that the League does throughout the state. And I think that we are on the precipice of making something happening that both the League and Modern Courts have worked on for many, many years, and that's court simplification. So we have with us tonight to present the Deputy Executive Director, Denise Kronstadt, and a lobbyist who is working on this project up in Albany, Dana. And I'm not going to say any more. I'm just going to sit back and enjoy the show, and I hope you do as well. We are taking, at the end, some chat questions or whatever so that we can answer you in person if that's possible. And if not, we'll follow up with anybody who has any questions whatsoever. So thank you so much, Laura, who is on our board now, recommended by Libby Hubbard, and Erica for setting this up.
Hi, everyone. I just want to again thank Erica, Millie, and Laura for setting up this meeting. It's very wonderful to be here with everybody. The lobbyist working on this is Dana Caro-Tenuto, who will join me in this presentation. I think she's a little exhausted because she was in Albany all day today. So she hustled back to sit in her seat to talk to you all. And as everybody here who's lobbied knows what that's like. So what I'll just want to, before I begin, I want to say that before, and it kind of makes me a little sad, before we were in the shutdown, the last presentation I gave was on court simplification up in Saratoga in person. And I have very strong and fond memories of that evening, if anybody here was there. And we're still working on this because the pandemic certainly took away an opportunity to deal with this issue. I'm hoping everybody here is healthy and well, and looking forward to getting back into our lives again as best we can. So thank you for being here, and I'm going to share my screen. I may have a couple technical issues here and there, so just bear with me, and I'll begin the process. So I'm assuming you can all see this. The title of our presentation is Equal Access to Justice, the Fight for Court Reform and Simplification. Because simplification is a reform, it's a systemic reform, it's a change, and it's significant. So much of the foundation of our current court structure dates back to the original state constitution in the 18th century. And all three branches of government, the governor's office, the legislature, the judiciary, as well as organizations like the League, business organizations, advocacy groups, legal service organizations, bar associations have all launched various efforts to try to simplify the New York State court system. And as that last sentence says, however, few, if any, have seen their recommendations adopted by the legislature. And Dana, I think, will speak to that. And I would just say very simply, one of the reasons why that is it's really complicated to change government. And you'd be changing one branch of government to be something different than it's been for decades and centuries. But it's time. So right now, New York State still has one of the most, and all these adjectives, right? Archaic, complex, bureaucratic, wasteful, balkanized setup. And what that does is create radically different experiences, and one may say radically different results and access to justice for the people, the litigants, the families who depend on going to the court to find solutions to issues in their lives, whether it's economic, whether it's about housing, whether it's about security, whether it's about safety. And depending on people's backgrounds, depending on who people are, there is definitely discrepancy in what kind of justice people get as a result of how the system is structured. And this also costs the state and all parties time and money. And I've always liked this quote and this illustration. Can you see this illustration, or are we in boxes on the side? You can see it? So this is from a director of an organization that serves women living in poverty. 80% of them are survivors of intimate partner violence, 73% are mothers, many are immigrants. Our court system is so confusing and onerous to navigate that many of our clients have opted out of the system by the time we meet them. So even before you get there, you don't go. Once you get there, it's also complex and difficult and impossible, but many, it's too hard to even enter the door to get your relief. And on this side, you'll see this is the number of courts in New York: village and town justice courts, which will not be touched by what we're about to speak about. District courts, those are on Long Island. Civil court in the city of New York, criminal court in the city of New York, city courts across the state, city of Buffalo, city of Rochester, Long Beach, Peekskill, etc. Family courts is one in every county. Surrogates court, one in every county. County courts are one in every county outside of the city of New York. Supreme Court, all across the state. And the Court of Claims, the court where you sue the state. So these are our various courts. And each court has different power to hear different cases. And except for certain exceptions, particularly in the Supreme, they are limited as to what they can hear because of the nature of that court's power. So just as an example, because sometimes we speak about things and go, well, you know, courts are complicated and we have lawyers and there are rules. People can need it. Just to explain why New York is so insane. This is California and this is New Jersey. All those courts you saw in the previous slide, down here, all those different powers of the court are heard in the Superior Court in California or the Superior Municipal or the tax court separate in New Jersey. New York is an outlier. Here's another, this is the map of the United States of America, as you all know. And New York is red. We have 11 different trial courts. If you look at this map, you'll see next to us is Georgia. After that is, I guess, Connecticut. Or is that Rhode Island? Rhode Island. So what we want to do is take this system, simplify it, restructure it, consolidate it, so that you have town and village justice courts. They are not part of this resolution. They have nothing to do with this. They're just out there, so we wanted to put that in here. You take your city court, your civil court, your district courts, your criminal courts, and you make one municipal court. Take family court, surrogate, and you make one Supreme or Superior Court. So what does that mean? What that means is all those variety of cases that would be heard in these disparate courts get heard in one court, maybe in a different courthouse, but you walk in the door and your cases can be heard in that, all the different kinds of cases can be heard in that courthouse. So dysfunction leads to delays, increased costs for litigants, and injustice. We said that already. I love this graphic because I think it really well describes somebody and what they face when they see the massive variety of places that they might have to enter and what do they do.
Around the world. We are going to be very clear that
So there are similar stories in family courts and housing courts and the so-called lower courts, family, housing, city, criminal, civil New York. So families in crisis may be forced to go to court from court to court for separate adjudicating of matters, whether it's domestic violence, custody, child support, matrimonial. Children and others in guardianship cases might have simultaneous proceedings. Some are in surrogates court where guardianship is, and some are in family court. Injured individuals where there's a private party in the state have to go to two different courts. And then all the lawyers, you know, we have the lawyers in here, have to figure out what to do and where to go with their cases. Worse for those unrepresented, generally. So there are many stories of injustice, and at the end, I'll give you our website, and you can read them for yourself. But I'm going to read one of them. It's long and it's confusing, and don't try to figure out what's happening because that's the whole point. It's awful. Ms. S, originally unrepresented, entered the court system through family court. A survivor of domestic violence, she originally went to family court for an order of protection. While in family court, she filed for custody of her two children. Her spouse was served with those papers. She went back to family court and received assigned counsel for her cases. Her spouse also retained an attorney, and her children were assigned lawyers. So we have family court case, order of protection, and child support. Rather custody, order of protection and custody of her children, family court. After several appearances, she also filed for child support. So she had three things going on in the family court: order of protection, custody of her children, and child support. Child support is heard in the family court before a magistrate. The other two are heard before a judge. She had three cases going on in family court, two judges in that court. Her spouse files for divorce. You can only file for divorce in family court. You cannot file for divorce. You can only file for divorce in Supreme Court. You cannot file for divorce in family court. She commences the action in family court for the order of protection. She commences an action for custody. She commences an action for child support. Her husband gets the papers. He files for divorce in Supreme. Okay. So hearing about the divorce case, the family court judge dismissed the custody case that was going on in family court, saying, oh, you can go bring that in Supreme. Ordered that the order of protection was postponed, that hearing, and the support magistrate who hears child support postponed that case. She went to Supreme Court. Ms. S went to Supreme Court without an attorney, because her family court attorney that was assigned wouldn't do the divorce, wouldn't go there. The Supreme Court, aware of the pending family court matters, brought the order of protection into Supreme, but not the support case. She was assigned a new attorney for these matters. Her children's attorney wouldn't go to Supreme. She only worked in family. So they were assigned another attorney. The Supreme Court judge wouldn't bring the child support part of that divorce into Supreme, even though it's integral in the divorce. And that remained in family court. And the Supreme Court originally didn't want to bring all those cases together, even on the order of protection, but they had to, because then a lawyer came in and this was a legal services organization. So and if that sounds confusing, it's because it is. And there's no way you can draw a diagram of that. So, except maybe this diagram could tell it. I want to tell one more story. A tenant this was in the Bronx, was locked out of her rent stabilized apartment by her landlord when she was 7 months pregnant. She could not access her personal and medical documents in the apartment, nor those of her 2 children. This posed a serious problem for her because one of her children is disabled and received home health care. And the agency providing that home health care wanted to get updated information on her Medicaid, which was locked in the apartment. The tenant went to civil court at 851 Grand Concourse to file an illegal lockout petition and said her landlord was harassing her. The clerk told her that since it was housing-related case, she had to go to housing court at 1118 Grand Concourse. She slowly and laboriously walked over to housing court, where she was told by yet another clerk, although this was housing court, illegal lockouts couldn't be heard there, and she had to go back to civil. She started crying, and the clerk sympathetically started searching for the illegal lockout petition form to let her fill it out in housing court. Now, the thing on that case is, it was the jurisdiction of that court to hear it, but because we have this very siloed system, sometimes things don't proceed. If everything was in this one consolidated system, then anything and everything could be filed within those courts. So recently, there's a lot of media attention around this issue. Chief Judge Janet DeFiore, Senate Judiciary Committee Chair Brad Hoylman, Assembly Judiciary Chair Charles Levine, all have proposals to achieve this reform. And reform would create a more streamlined court system that has the authority to better distribute resources, to provide them where they are needed the most, to reduce court appearances and give all litigants a better and more equal justice system. Interrelated issues I just talked about could be decided in one court. And then there would be more judges in civil and criminal in New York City and more judges in the state overall. So there's also this impact on diversity, equity, and inclusion. And so simplifying New York's court system would enhance access to justice for low-income and marginalized communities, because it would untangle this labyrinth that really falls on the shoulders people of color, marginalized, and low-income people. People going without counsel, or even if they're with counsel, if they're lucky, it's still excessive and too many times going to court. So reforming the court system and structure requires an amendment to the state constitution. Now, I know the League has often worked on amendments. So often, many of you know how complicated this is. You have to have 2 separately elected legislatures vote on approving the legislation and then the resolution to amend the Constitution, and then you bring it to the public. So numerous organizations and individuals including the Fund for Modern Courts, the League, and others are involved in this campaign. And I just want to go to our website and then turn this over to Dana to add what she would like or to respond to questions. So one moment, I'm going to stop and then I'm going to share a different screen. So this is our website. It's simplifynewyorkcourts.org. And what I'd like to just show you is who was in our coalition. It's broad. We have multiple organizations that represent children that work in the foster care. We have immigration organizations, legal service organizations, bar associations, organizations that work with victims and survivors of domestic violence, good government groups, and others. And there's the League. So it's this broad range of people and organizations that support this. The other thing I wanted to show you is that if you wish, here is the page that has all the different stories. And there are many of them. And I would urge people to read them. You know, the task of writing these stories, many of them taken from testimony from people from across the state, to explain what was going on was really difficult. And then I realized, well, that's the problem. You can't explain what's going on because it's so complicated and so difficult. So I'm going to, I guess, stop my share and reach out to Dana or Dennis to add, and then we would be happy to take questions from anybody and further explain things that maybe I glossed over, because discussing the shape, the form, the jurisdiction, the problems is difficult. But I think that there's a generalized sense of it from what we put forward. And I hope that if you have any questions to ask them, but I'll turn it over to Dana first to talk a little bit about the advocacy and what's going on.
Sure. Thank you, Denise. My name is Dana Caratanudo. Previously, I have spent 20 years in state government. I worked in the New York State Senate and most recently the executive chamber before I went over to the private sector. I wanted just to give an overview first of sort of how we got here with the bills. As Denise pointed out, both chairs of the judiciary have introduced a bill on court simplification, Brad Hoylman and Chuck Levine. Currently, they're both in the Judiciary Committee. So that is where we are as a result of the bill's advocacy. Having been in state government for 20 years, you know, when I first got involved, I used to meet with people and hear their idea and policy, and I would say, well, this is amazing. Who would not support it? And I would run around and think that it was the greatest thing in the world. And then I learned very quickly there's always another side to the story, and there's always opposition, and there's always someone who might not be supportive of your policy or your idea. And you start to learn both sides of the argument. And that's true for a lot of things in Albany. But I feel for this issue, the policy and what has been trying to be done for over 40 years, 50 years, I think takes precedent over the opposition. And I think it's mainly because of the fact of the story that Denise referenced at the beginning of an attorney talking about how women who are seeking help and relief in the most difficult situations of their lives might not seek that access to justice simply because we don't have a court system that will allow them to feel comfortable doing that. And that's one story. And as Denise pointed out, on the Fund for Modern Courts, multiple stories, we have multiple New Yorkers who are struggling to be heard. And this is an issue where, learning more about it, I understand why the League of Women Voters have been involved in this issue for so long. This is an issue that puts policy over politics, and it puts people over party. And that's really what it is. And it is a difficult conversation to have. One, because as Denise pointed out, it's confusing, right? If you are not a practicing attorney, and all of our state legislature, we're seeing less and less practicing attorneys and more people coming from different areas of advocacy, which is great and it's fine and it brings a new voice to our legislature. But if you've never had to use the courts, or if you've never worked in the courts, understanding why this is so important and understanding how our court system works is imperative for making people understand why we need to simplify it. So that's one of the challenges that we have, and we see a new legislature and there's new faces coming up. So whether or not it's someone who's been there for 25 years or a year, it's re-explaining this issue. Secondly, there is opposition. Why is there opposition? Sometimes people like things to stay the same. There are people who sort of, like the way the court structure works, understands how the court structure works in the courts every day, and feels that everything is sort of working the way it should be. And maybe there's some tweaks around the outside that need to be done, but no fundamental wholesale change. And again, if you hear that argument, that makes sense, right? And you sit there and you say, well, maybe you people like it the way it is. Why should I bother? Then you read these stories. And then you read the stories about the people that are trying to access the courts. Remember, these stories don't come from the top. These are not the stories from the chief judge or our appellate courts. These are stories from people at the bottom, the legal aid attorneys, the pro bono attorneys, the district attorneys, and their clients who have the courage to sort of tell their story. So this proposal is really giving a voice to those people who have struggled every day to access justice in our courts. But again, I don't want to sit here and say that people will not have arguments that will sort of make you sit there and think and wonder. But if it was easy, all of these changes would have been done, right? When people say, well, you can make a tweak here, or you can do something over here. Why don't we do an administrative rule over here, or put some more resources here? Piecemealing reform of the courts gets us exactly where we are today, that we were 5 years ago, that we went 10 years ago, without a consolidated way to deal with all of the challenges that everybody sees in our court system on a daily basis. And a constitutional amendment does no favors for our judiciary. What it is a mandate from the people to say we need to do better and we need to change the system. It is helpful that right now our sitting chief judge, as was our previous chief judge, and our previous chief judge believes in and supports the consolidation, but this is in no benefit to her, because when this gets done, as Denise pointed out, it's one constitutional passage, as all of you know, because you are probably more experts in it than I am, and then a second passage on a second sitting legislature, and then it goes to the voters. This is no benefit to our current sitting chief judge, who will not be our chief judge by the time it's all implemented. So this is really about people sort of going out to vote to say, I want a court system that works. I want a court system that makes sense. And if there are people that don't agree with how this court simplification is done, then let's see how we can do it. But let's all row in the same direction, right? Because if we sit here and we piecemeal reforming our courts, we will never ever catch up to where other states are that have a simpler system that allow people to access justice and allow people to actually feel comfortable when they walk through those doors of those courts. So we are trying our best with many of the people that Denise have sort of pointed out, advocates, domestic violence legal groups, legal aid societies, immigration groups, urban justice groups, to educate our legislature on number one, what this is, and number two, why it's so important, and also to not shut our ears to suggestions that they might have within the structure of the constitutional amendment to make it work for everybody. So currently right now, we are reaching out to members of the judiciary. We are speaking to legislators all over the state to get them to start thinking about this and having the conversation, because it's too important to let another legislative session pass by without having a real conversation about why this is important. So that's kind of where we are. I don't know, Dennis, if you want to add anything or if you want to open it up to questions that Denise and Dennis can, address on the technical aspects or anything else on the advocacy part.
The only thing that I would like to add is that I use the term precipice of change at the beginning of these remarks. And it really is a precipice, because if this doesn't happen within the next 5-6 weeks, when the legislature is scheduled to end, currently it's scheduled to end June 2nd, it means we'll have to start all over again with the newly elected legislature next year. And then it'll be delayed another 2 years for another newly elected, and then there'll be a referendum. So there's an urgency, a sense of urgency about getting it on the agenda of both legislatures this year and within the next few weeks. And we know that many members of the league have contact with their legislators. We're not asking you to explain all of the reasons, but if you are talking to a legislator, you can let that person know that this is important. We'd like to see them get on board this session. And if they need any further explanation, Denise and myself and Dana are all available. Although I think the website does a great job of explaining things. And I was legislative counsel to the Education Committee back in the 70s, late 70s. And as counsel, when people came to me with information I didn't know, I used it. I relied on lobbyists. Even if they had opposing positions, it educated me so I could educate my legislator. So someone in a legislative office can do this work and educate the legislator and hopefully move this along. That's all that I have to say. And I guess we will be open for questions. I think that we're going to use that raise hand feature to call on people. And I'm not in charge of that, so I'm going to get off.
Thank you so much, Dennis, and thank you, Denise and Dana. That was really wonderful. So we will shift now to questions. So as Dennis said, you can either use the raise your hand function and I'll call on you, or you can type your question in the chat and I'll repeat it just so that everybody can hear it, and then hand it over. So it looks like we have one hand raised. So Marlo, you can go ahead.
Hi, thank you so much for everything that you're doing. I work with the Westchester League, and I am a survivor of 6 years in the matrimonial part of the Supreme Court and the family court, as well as the family court. And I want to thank you for all of your efforts. It would be hard from my perspective to categorize the courts as anything other than a complete failure from my experience. Because they are so unnecessarily complex and in so many ways incentivize and prolong litigation and malicious litigation abuse. And they are completely overwhelmed and understaffed. So I appreciate everything that you're doing. My question is, as a person who was financially exhausted in the Supreme Court and forced to go pro se, I found that the family court was at least had protections for pro se litigants in terms of the simplification of procedure. and just other protections for pro se litigants. And I'm just wondering how would these protections be applied in the sort of consolidation of the court? So if a pro se litigant if the courts were consolidated, would pro se litigants still have those same protections, or how would that work?
I mean, I think I would ask Dana this, but here's what my understanding is. This entire campaign has to do with ensuring people like you and others get the best justice results that you can. And we do get this question: what happens to family court where there's no cost to petitions? What happens in these pro se parts where there's better services sometimes for people that are pro se? There is a 5-year implementation period in this, and that period should include, we hope, an opportunity for the various court rules that differ from court to court to court to be streamlined, to be thought about, and to be inclusive of the ideas like you just raised, Marlo. So that's how I would respond to it. I don't think anybody working on this is going to have the referendum pass, which is hard enough to get to, and then drop the ball on all these issues that we hear often, that exact same question, right? What the things that are put in place now that help people, are they now going to be gone? Well, that would defeat the purpose. So that's the best I could say. There's no procedures that have been written yet to ensure that, right? But we all have to ensure that. So I'm going to turn that over to Dana if you have a different response, but that's, unless there's
No, I agree. I think that's exactly it. I said the goal is to take what we're seeing the best in our lower courts and in a simplification and consolidation to take those best practices and see them in that consolidated lower court. And it also allows the resources to move freely as well, right? So in a consolidated court system and the structure that we lay out, the resources that are needed to be addressed in our lower court systems allows us to move it freely, as opposed to seeing a disaster happen in one court and then sort of have to scramble to sort of address it in that one court and then take resources from another court. But I think you're right. I think the best practices that we see in our lower courts will be reflective in this consolidated court system.
Denise or Dana, could you give, for everyone on the call, could you give us a quick definition of a pro se litigant?
Pro se litigant is a person that goes to court without an attorney. So it's Latin, and Dennis probably knows the Latin translation. So that's what pro se is. Pro bono is when a lawyer represents somebody without cost. They don't charge a fee. Pro se is a person that's an unrepresented litigant. Yeah, we do that, lawyer. We all do that. We use those words as if everybody knows what the hell we're talking about, and that's part of the problem. There's
if you imagine, if we're getting these stories from attorneys, from legal aid society, and again, district attorneys and such that are having such a hard time with their clients, can you imagine being someone without legal representation trying to approach our courts right now? I mean, again, it goes back to the same story. People just don't bother. And unfortunately, they live without access to any help, and our court system should be open to all and be easily navigated. So it is scary to think about those people who don't have counsel and have to approach the court system now.
If I could, may I follow up? I'm sorry. May I ask a follow-up?
Go ahead, Marlo.
Okay, just thank you for that response. I just wanted to say, first of all, that I wanted to ask, first of all, if there will be a way for the public to provide input to all of these considerations that you're going to have to deal with in the implementation period. And I just wanted to also say that I think that there can be a bit of a misconception about the family courts as a place for, for families with no assets. I'd have to say that myself and many others, that start out in the Supreme Court have significant or even substantial assets, but wind up in the family court because the litigation is so prolonged and so financially exhausting. So, I mean, they're actually sort of, and eventually anybody that starts out in the family court, in the Supreme Court may end up in the, pro se. So just something to, I think, it is, I agree with the in general with the sort of the characterization of the family court, but and the problem is immense. And again, thank you for everything you're doing. But I don't think that the extent of the problem is even fully realized because anybody that starts out in the Supreme Court may eventually end up in family court, or by which I mean to say they may end up unable to afford an attorney. Thank you.
Yeah, and Marlo, I just wanted to weigh in with, we have heard from many people that we talk to that there's a culture in family court that actually supports litigants, and we don't want to lose that, as Denise said. The problem with family court as it exists, at least in New York City, is that the judges in family court have 3 times the calendars of Supreme Court judges, which makes it virtually impossible for them to give more than 5 to 10 minutes to each litigant that appears in their court. By merging the courts, we will be able to, the chief judge will be able to use the resources throughout the system so that family court has enough judges to work on problems and reduce that caseload. You can't have an efficient system or an effective system if there are too few judges to handle the volume of cases. So yes, let's preserve the culture, the welcoming and supportive culture, but let's give family court the resources that they need.
Yes, thank you.
Okay, looks like we have a couple of questions in the chat here. Natalie, I also see your hand raised. So our first question is from Nancy. Nancy asks, what is the current status of seeing this change occur? Dates?
Dana?
I apologize. So this is a long process. So this is not, as we mentioned, first and foremost, in a perfect world, you would see first passage this year. Then since we are going to be sitting a new legislature, God knows when, based on today's court ruling, but eventually we will see it in a new state legislature. Again, in a perfect world, we would then be able to do second passage in that new sitting legislature. Then it would have to go on the ballot for voting. And then after that, so say, I don't know, 1, 2, 3, I believe then all of us, then you have to have time for the implementation of the consolidation of the courts, which I think is a 5-year implementation period. And Dennis, you can correct me if I'm wrong. So it's a 5-year, because remember, we are consolidating the courts, we are elevating judges, we are ensuring that we make sure that we keep court personnel in place. We are aligning court procedure as well, and all of the procedural rules that are there. So this is a very lengthy process. But where are we now? We're hoping for first passage in this session that will allow us to do second passage next session. And again, many of you are probably better experts at this than I am. However, as you know, if it doesn't pass this year, then we would want it to pass next year, but then we would have to wait for another sitting legislature. So first passage next year would require us to wait at a minimum 2 years to get second passage. And then we go to the voters, and then there's a 5-year passage. So it's a long process, but we've waited 40 years. So I feel like 5 or 6 more years to implement it is a better timeline than waiting another 40 years.
Thanks, Dana. Our next question comes from Kim. Kim asks, why are New York courts so heavily bureaucratic compared to other states? Is going to court in New York much more expensive than in other states?
So I just want to point out that on our website, there's a history of the courts, and that may help answer that question. And I would also turn to Dennis, who's very familiar with the history. It really goes back to the fact that we are one of the first original colonies and how courts were established at that point, and then what happened along the way. And then in terms of it being more expensive, I honestly don't know the answer to that question, whether it's more expensive or not, or what the metrics would be to even make that determination, because, you know, there's so many elements to it. But Dennis, do you want to, or can you address the bureaucratic compared to other states?
Well, I think one of the things that I always find interesting is, you know, the law of unintended consequences. More than 50 years ago, when the legislature and the people were concerned about family court matters, they created the family court as a way of providing the kind of different support that families in crisis needed, different than lawsuits for property damage or personal injury or contract, which are all in Supreme Court. The problem is that during that 50-year period, the resources that were necessary to support the huge number of cases that come into family court were never provided. And in a siloed system, it is difficult to move judges or to move personnel from one place to another. So some of it is just, you know, an attempt, and sometimes we call it the Band-Aid attempt. You have a problem, you put a Band-Aid on it. And that doesn't really work. If you have a system that's hemorrhaging, as our court system is, you know, you have to do major surgery. And that's what court simplification is. It's a major change in the structure that will support people whenever. On the cost factor, the only thing that I could say is that, you know, if you do have an attorney, and that attorney has to make multiple appearances in multiple courts, they're going to charge you more money. So it's more expensive to the client. But as we've said, many of our clients have no representation at all. Many of our citizens have no counsel at all, and are taking days off from work, which can be very expensive. If you could go to family court and resolve your problems in one sitting, you would only have to take one day off. Because that isn't the way the system. Cases are constantly adjourned 4, 5, 6 times. People are forced to take days off. And one of the reasons that business associations support simplification is they don't want to lose good workers to family court 5 days a year or 6 days in 6 months. So it increases the, you know, it costs more to the individual, it costs more in terms of attorneys, and it costs businesses more not to have people coming to work in a timely fashion.
Thank you, Dennis.
Dana, were you looking to address that too?
No, you guys are wonderful. Good.
Our next question comes from Natalie. Natalie, you can go ahead and unmute yourself. Natalie, do we still have you? All right, we'll loop back to Natalie a little bit later. Other questions, either type them in the chat or feel free to raise your hand.
There's a good question in the chat that I would direct to Dana, which is, will organized opposition surface when we are a few votes away? And,
Yes.
Thinking of healthcare, that's, oh, is that from Linda Burns? Hi, Linda. Okay.
I don't see that question, but yes, absolutely organized opposition will surface. You know, there is opposition out there. Look at, I'm a very honest person. I never ask people to put their reputations on the line for anything without them knowing what they're walking into. There is opposition out there. You know, there is opposition from some judges. I have a very high respect for the bench, but again, there is an opposition from some judges who like the structure of the courts as it is, like sort of how where they sit in the courts, our lower court judges, where they are, our higher court judges, like the structure of it. And I get it, right? You know, you work hard, you go to law school, you're appointed or elected a judge. This is sort of what you know and how you've imagined your life to be. And here comes some, from modern courts and us and saying, well, we want to change the way you do business. I get it. But again, I go back to the point of there's always opposition on an issue, but there's some opposition that I think has to be overweighed about who we're serving. And this issue, again, doesn't serve me, doesn't serve the judges, doesn't serve the lawyers. It really serves the people who are supposed to be accessing the courts. So yes, there are judges that are opposed. There is some labor that is opposed as a function of, again, as we probably all know, in some parts of our life, when people talk consolidation, people freak out. They think about attrition, they think about losing their jobs, they think about cutting resources. But if you look at any of their opposition, they believe in the conversation about consolidation, but they just want to make sure that their jobs are intact. And OCA is reaching out through their labor negotiations to sort of ensure them that whatever structure they have, they are going to be working with labor. That's kind of where most of the opposition comes from. And like I said, I have respect both for labor and for, our sitting judges. But for me, it's sort of, if you tell me how to address your problem within this legislation, then we can address your problem within this legislation. I think there's an openness and a willingness to make sure this works for everybody, because if it doesn't work, because the goal of this is to make sure that we have access for every New Yorker. So, but yeah, organized opposition is expected at every point.
Our next question comes from Loretta. Laura wants to know, did she understand that village courts would continue? Correct.
I'll respond to that. So the town and village justice courts will continue as they are. The legislation proposed doesn't change those courts. Those courts are not part of the unified court system. They are separate and apart. Those judges are paid locally, and it's they have to follow the laws of the state, one would hope. But though not part of the unified court system, so they are not included in this consolidation proposal that's been put out by the two houses.
Thanks, Denise. All right, so our next question is from Natalie. Natalie asks, what will force the judges to move the cases along? Court simplification is great, but if your judge just wants to drag it out, will they still be able to?
I'd like to answer that one, if you don't mind, Denise. One of the terrific things about our current chief judge from day one is that she introduced what she calls an excellence initiative. And all that it really is setting standards for moving cases along and for disposing of cases in a timely fashion. And those guidelines have always existed. And some of the local administrative judges are hard on judges who work in their area. But the judges are all separately appointed or elected, so sometimes they don't respond well to those kinds of proddings, and saying, correctly in some cases, the wheels of justice grind slowly but fairly. On the other hand, each year the chief judge reports on the success of this so-called excellence initiative. And when you have someone at the top and the leadership in OCA, really looking at it and pushing it, simplification, that initiative will continue when the courts are simplified. And I think it'll actually make it easier for judges to resolve entire problems, whether it's custody or visitation or child support or divorce or orders of protection. It'll actually simplify the resolution of a final disposition to the judges, and hopefully that will help move things along as well.
Dennis? Could you all talk a little bit about, I know some judges are appointed and some are elected. Will that change, or how will that be implemented within the new simplified court system?
Taking this tough one. So I'm happy to do it if you want. So in the state of New York, there are different ways that we appoint, there are different ways we select judges. Some judges are elected, some judges are appointed. Some judges are elected from their county, family, surrogate, county court judges. Some judges go through a judicial convention system in a district, which is multiple counties. Some judges are appointed, like in New York City, judges in the civil court are appointed through a commission-based appointment system and then by the mayor, and the same is true for family court. City court judges are elected through their geographic place. This has always been one of the more difficult things to explain, and also one of the more difficult things to resolve as we do court consolidation. And it might be the very essence of the difficulty in making this happen. When you move the judges, whether they go into the municipal, when you change the courts, and whether they go into the municipal court, those lower court judges, or they go into the Supreme Court, family, county, surrogate, Supreme Court of Claims, the positions of those judges, when the next person comes up, they will be selected in the same way that that judge was selected. So if it's a Court of Claims judge that now becomes a Supreme Court judge, and that person's term is up, that position will be appointed by the governor. If it's a family court judge presently there that moves up into Supreme, and that judge's term is up, the next judge, or even if that term that will be elected if it's on the county basis. So every position will be selected in the same way that it was previously. It's just that they'll be serving in a different court. That's how it will work. Complicated, very complicated. I like to say that in California, I think it was in the 1980s, they were able to consolidate their court system because there wasn't this cockamamie thing about how you pick your judges. It's different there. So they didn't have to resolve all those pieces of the puzzle. So that's how it's going. That's the proposals, and that's what has been studied and perceived as a way to ensure that this moves forward, because once we start changing that becomes a whole nother animal. So I hope that's clear. I'm happy to do another session on how we choose our judges, but the league is certainly very familiar with that and is often with modern courts on those issues. So
thanks, Denise. I think you made a complicated system pretty straightforward, so I appreciate it. All right, it looks like we've got maybe one more question in the chat here. Marlo asks if legislators, it's kind of a multi-part question, but if legislators are uninformed, isn't visiting the courts the best way for them to learn about the overwhelming dysfunction?
Yeah, I think, visiting the courts are the best way to learn about them. And again, I think legislators are very aware of the complex and difficult nature of navigating the courts. I mean, we have, we sort of pass it off as COVID related craziness, but we were seeing with our housing courts and such. But, I think legislators are aware. I just don't know if they're aware that there is a path by which we can fix all of this through this legislation, as opposed to seeing a problem on Channel 7 News or Channel 6 News if you're in Albany or wherever, you know, the local news, and sort of putting in a bill that sort of, you know, puts a Band-Aid on this particular issue because you're seeing that maybe that, you know, cases are not moving quickly, or there was a non-communication between the family court or immigration, which we obviously saw a lot of horrible stories that were happening to some of our families in immigration court. So I think they understand it, that there's a problem, but I just don't think they've taken the time to really figure out that this proposal will address a lot of the ills that they see without having to do a piecemeal Band-Aid approach to the multiple pieces of legislation. Manny Ligon's reaching out to legislators, asking them to sit in their court. Look, if people are speaking to their legislators and they want to say, why don't you go sit in family court one day, or why don't you go sit in housing court one day and then come back to me and tell me you don't want to do this, I'm all for that approach. That's kind of my approach. You take the approach that you do, but I agree. I think that we can't be lazy on a solution that has been thought out. And again, I stress, and the League of Women Voters knows better than I on this. This is not something that was put together overnight 2 months ago. This is a well thought out, well vetted, prior to Janet DeFiore, Judge Lippman, Judith Kay. This is not an issue that was done with political expediency. This is something that has been thought over, discussed, ruminated, tweaked. So, but whatever you think, your advice in moving legislators, I will go to your last point. I'll go take a recording at a court and I'll send it out to all of them. I think there's different ways to get people to open their eyes, and that's what we're hoping to get guidance also from all of you who have experience in speaking to some of our state legislators and sort of the things that motivate them and move them.
Thanks, Dana. Ruth, I see we have a question for you, but just before you, we had a question from Paula, so I don't want to skip Paula. Paula, do you still have a question?
It sort of was answered now, and as I think back over the years about our being involved with, doing something about consolidating the courts, but my concern has always been that whatever you are trying to get, it doesn't always happen the way you plan it. And that's part of my concern, between the original idea, the bill, and then the implementation, a lot of things can happen.
Yeah, I never believe that what's on pen to paper that you start with is what ends up on pen to paper. But again, I think that's also the beauty of the legislative process, and I know, at least from our point of view, if it's a good idea and it makes the bill better. I mean, again, we talk about the benefit of this not being drafted overnight, but obviously our society has changed, our courts have changed, our laws have changed, our constituency has changed. So there might be a better way to approach pieces of this where we can have a conversation about how to make it stronger. But I think the core part of it remains the same and goes again back to Denise's presentation. We should not be a state that talks about access to justice and is fighting for all of these resources to be for New Yorkers so they can get a fair trial and they can get a fair court experience, and be a state that has this archaic 9-piece court system. What is the benefit of what we're advocating for if we're not willing to sort of have a court system that could actually implement these important changes that we're doing in other parts of our laws?
Thanks, Dana. Go ahead, Ruth.
I just wondered what part of all of this big problem is political, or is it not political at all?
again, with all due reference to our sitting judges and those that are in opposition, look, there's always, I mean, you guys know, there's always politics, right? And everything that is done, whether it's at the city council levels or your local legislative levels or our state levels, yeah, there's politics involved. People like the system, people like to be elected, people, like the structure that is put in place. But again, I don't fault anybody for that, because again, as I state, people go into a system knowing what that system is, they train for that system, they are educated in that system, they know how to navigate it. So we're asking to change everybody's world a little bit. But there's always politics in everything we do. But again, the work that the league has done on issues in this state, and particularly this, I think is the greatest statement, because of the fact that, again, you are not politics, right? You're policy. You're not party, you're people. And that's the greatest validator for an issue such as this. And that's my most diplomatic answer I can give you on a public Zoom.
Dana. Do we have any other questions? Either feel free to raise your hand or pop it in the chat there. All right. Well, thank you so much for joining us tonight, everybody. Thank you, Denise and Dana and Dennis. For those of you who are on the call, if this is an issue that you're interested in, it is an issue that has been included in our post-budget advocacy packet. So I definitely encourage you to talk to your local league about lobbying for this issue as a part of your league. But thank you so much for joining us on the call tonight and for your great questions. Feel free to reach out if you do have any additional questions, and I can send them over to the Fund for Modern Courts to get your answers. All right, but thank you. Thanks so much, everybody. Take care and have a great evening.
Appreciate you all.
Thank you for having us. Be safe.
Thank you so much.